Wait, item number 1. This matter, I was required to file an amendment. Item number 1, I was required to file an amendment application. I'll file it this week. I'm sorry.
Wait for your matter to be called up. Why are you making a mention of item 1? Let the matter be called up.
May I please, Your Notice? I beg to mention item number 11, It's an admission letter, Your Notice. I'm filing my affidavit in opposition during the course of the day.
Item 11 on the request made by 11.
11.
You're for?
I am for the respondent.
Respondent, sir.
He is for the petition.
You responded.
Lordship, explain this. Not this. Not before this. I'm sorry.
You're wondering.
Take to mention for listing of the one urgent matter.
Urgent.
Fine.
Motion matter.
Motion matter.
Tomorrow.
Fine.
Tomorrow.
Must.
Fresh.
Fine.
Fresh matter. When did you
Fresh
file
matter.
it?
Fresh matter.
Tomorrow.
Well, mention item number 25. Well, this case, the civil respondent has filed an affidavit in opposition.
25 on the request made by Mr. Rai, so matter stand listed again. On Fourth of May.
25 and 26 tag up. 25 and 26 tag.
25 and 26. You are appearing in both. 25, 26.
One promotional affidavit has been filed Mr. Rema. This to be take
Which matter?
Item number 42 and 43.
42. They are connected matters.
Connected matter.
42, 43.
Mention of
Yes.
I beg to mention for listing and matter for motion for tomorrow. Oblige, Your Lordship.
Not admission day after. Admission will come in the after the vacation. You can have it on 27th. Content. When was it filed? Fresh matter. Huh? 2nd February. It is a fresh matter. All right. Before vacation, it is a motion day. They are coming for order. Is it coming for motion?
Yes.
Motion. All right. Have it on Monday, 6th.
May I please, Your Lordship? I would like to mention item number 5. This matter has been tagged with one lead petition 4845 and fixed on 4th of May. This matter may come.
It is submitted that this petition has been connected with WPC number
4845
of
2021.
2021. The matter is fixed on
4th May.
It's fixed on 4th. Therefore, council submits this matter be listed on 4th of May along with the final.
Oblige, Your Lordship.
Yes.
Tomorrow. Motion tomorrow.
Motion tomorrow. Okay.
Item number 4. Where for action?
Item 4. Item 4 of the request made by the council for petition stands deferred. Will be listed after 2 weeks.
After view petition.
After 2 weeks, yes.
Oblige. Item number 19. I'm taking nothing from the other side. My understanding also how to see
19 stands deferred to be listed after 2 weeks.
Wait.
For item number 1.
For item number
2.
wait, it will come now. Hang on. Yes. Yes. want to
file one amendment application, madam. It was ordered earlier. I will file-
amendment application. Counsel for the petitioner seeks liberty to file an amendment. So amended post title.
First title.
You have not filed.
I'm sorry, madam. I didn't file it.
Council has not filed the amended post title, therefore we say there may be allowed to start to 4 weeks. This will be
Assam Agriculture.
Assam. Mr. Nayak also?
Yes.
Mr. Nayak for finance?
Yes.
It's appropriate for respondent.
Legal worship. My lord, petitioner expired in the meantime. I need some time to substitute.
Submitted by the council. The report for the Disciplinary department. 2 and 5. Respondents 2 and 5.
Kindly realize.
Then I have for impediment of battalion, that would be respondent number 6, as all the orders were passed by this the commandant of this battalion for the connected.
Any objections? I number 751 26. 5. Respondent. Submitted that, I submitted that. So,
Yes,
excuse me,
yes, ma'am.
stop, the said order was passed by the commandant, 30th battalion. Said of department number 6 in the IA, that's the department. Party respondent number 6 in the BC 462. File amended post ID. The petition you right. Order passed today in the IA. The petitioner will file amended post ID. Matter will be listed thereafter. Mr. Beach approval form. Passed over. Yes. Yes, Sharma. Yes, for the health.
No, PW.
For the state as well.
Father of the petitioner was retired as a pharmacist and he was in necessity of pension. Their mother was pension, she also expired. In the meantime, the petitioner got divorced from her husband. Well, what happened, the petitioner is a divorcee daughter, man. She is claiming pension before the authority by submitting an
Who is claiming pension?
petitioner who is the divorced wife.
Divorced daughter.
Divorced.
Divorced dependent daughter.
What happened was she filed a representation before the authority, but the authority outrightly rejected that she is not entitled to get pension. This honorable court has held that
Third counsel for parties.
no, may pray, my lord. Lordship may direct the petitioner to submit a representation to the authority.
You have to decide it. Authorities can't decide that.
The similar cases, my lord, wherein this court has
Similar
already
cases have not laid down a law. That same order want it to be passed in your matter.
Well,
It can be done by the authorities.
that's
So we don't want to do it today without issuing notice. We have to issue notice to them. Third counsel for parties. Is for one,
One,
3, 1 and 3.
one it.
They both have to go number 2. I.K. Talukdar. R.K. Talukdar for respondent number 5. And Mr. Sutia is for respondent number 4. Director of Pension, respondent 4. Respondents presented by respective parties. After the returning.
all right. Petitioner was appointed as an office peon, 2018. He's a graduate and having a diploma in computer application. Now, as per the Assam Ministerial, District Ministerial Service was 1970. 10% of this post have been filled up by promoting or rather appointing this grade 4 employees having the required qualification of 7 years and graduation plus diploma. Now, his beloved learned that this posts are going to be filled up, but then all the posts are going to be filled up by direct recruitment. Therefore, he is before lordship.
Notice at this
Fine.
And there is a lordship state level recruitment board regarding grade 3 and grade 4 posts. Now the department doesn't fill up the post lordship. All these posts of all the department lordship are clubbed together and it is repeated directly by the state level
we
recruitment.
are issuing notice, you raise this in
And,
your.
and they are the necessary parties. Lordship.
I'll admit that.
You raise them,
I'll admit that. Yes.
you raise your objection.
I'll admit that.
Why this is an education matter? Why?
Yeah, this is also a bench to matter. This is also another thing. Lordship.
I was a little surprised as telling
I was supposed to state that, but I didn't know. See,
but since it's a service matter, that's why he's in the office.
should have come before
That's
the
the reason why
court.
this.
We are issuing notice of.
Yes, sir.
Huh? Service matters of education are before bench 2 only.
Oh, yes, Lordship.
But the roster says academic matters. That's why there is no confusion. I don't know. I was also not sure.
Counsel for parties.
1, 4, 5, and 6. Lordship.
1, 4, 5, 6. What about 3 directors? 1, 3, 4, and 5.
Oh, yes, 3 is also yes. 6 also.
There is no 6, 1, 2,
Ma,
3.
I don't have any respondent number 3 in my petition. Lordship.
Director education.
It is not director of school education. 4 is there. There is no 3 Lordship in my petition.
APS
One
for the
number,
education
number.
department.
Oblige.
This against termination also.
Termination from service. Appeals.
There is no provision of termination. It's a contractual employee or not. Not.
State respondents. Respondent 3 and
Okay,
4.
1 to
3
4
and
and
4.
Or 3 1.
Only 3.
Yeah.
1,
4 and 5.
4 and 5. Which is a good step. With problem.
Senior is the method of one and possible for timing.
Forest. So BTC.
I'm preparing for the our name may be
Name the whole council.
This recruitment was respondent. Was respondent well my promotion and implement into pending disciplinary proceeding. And that departmental proceeding is pending since 10 years. Fault of the department that departmental proceeding is not finalized. So as a result, I am suffered lordship. Lordship, I am going to be retired on 30th of October this year. Lordship. Still now they have not finalized departmental proceeding, and my increment was withheld. Lordship. Promotion and increment.
Yes, Mr. Nath, any instruction?
No, this has come for the first time. Can you give me 2 weeks time? I'll get the instruction.
Council for parties. Okay, 3 weeks. Mr. D. Nath, the appeals for respondents number.
All
the respondents.
Okay.
Therefore, notice is the way next to go. Respondent will reprise the court the status of the departmental proceeding stated to be initiated in the commissioner and pending. Initiated and pending, you can say, by the next day. For instruction.
First, we have, what we have provided the pension paper. Document, hard copy forwarded, but in a portal.
This document not being supposed to. I've got my instruction. For one, but if account number was not disclosed. They were supposed to take instruction on this document.
Then it captain for parties. It's return in 2 weeks. Mr. Ansari appears on behalf of
I am respondent number also.
respondents number.
Respondent number 3.
Respondent 3. Mr. P. Sharma for respondent number 4. A. Banerjee 1 and yes, Sharma for respondent number 5. The counsel for the accountant general, Mr. P. Sharma submits that the application, the proposal of pension petitioner towards family pension forwarded from the return back as far back as in July 2025 on two grounds, namely that they were not uploaded in the QuickTime data portal and the GPF account number was not furnished. Huh?
That is now.
So, but the respondent BTC will apprise the court on the next date the status of the proposal required to be uploaded in the web portal and the formalities connected there to be completed. So, let the instructions be placed again before the court on 29th of April. Extra copies be furnished. The extra copy already furnished. Already furnished, if not already.
The second, transfer.
Now, what is your ground for telling?
Earlier, Lordship has basically on the ground that whether there is any spouse posting policy or not, madam, that is where Lordship has directed the petitioner to file a detailed representation. And petitioner has filed a representation. But madam, without discussing, without it, and Lordship has also directed to pass a speaking order. Madam, kindly see the page 70, madam.
That is a speaking order.
Madam, that whether
It
there
may
is
not
any
appear
spouse,
to be a speaking order for you, but it is a speaking order.
whether there is the spouse posting policy is there or not, they have not that issue has not been addressed. I have health department has uploaded the kind of transfer policy
The order which was by which the representation was directed to be disposed of. Where is that order?
Lordship may kindly come to page 58, madam.
58.
Yes.
58.
58. The Lordship will, that's relevant portion starts from page 60. Paragraph 7, madam.
Direction that spouse policy is to be.
Lordship has, in paragraph 3, Lordship has discussed, madam. Paragraph
We
3.
will not discuss. We are recording your submission.
Yes, madam. Well,
Is there a direction?
On that point only, Lordship has directed the authority, on that standing council was asked whether that policy is there. And I have submitted before the Lordship, one draft transfer policy was there. That was one minutes of the meeting held in a conference hall in the on 27/11/2015, and it was uploaded, and whether it is still acting, whether it is finalized or not,
What draft?
transfer policy,
Where is that?
I have given a copy.
Draft policy, why are you giving it to us?
Well, kindly see, madam. Minutes of the meeting held in the conference hall of Additional Chief Secretary to the Government of Assam Health and Family Welfare on 27/11/2015 itself. Now it is 11 years, madam. And in page 4, madam, the last page, madam, paragraph 6, the top, madam, fine. If the husband and wife both are in the service of Assam government, efforts will be made to locate them as near as possible. One service.
Is that policy not in force now?
No, my lord, now only he has informed my lord that it is a draft.
Otherwise, there are husband and wife transfer policy in force. Otherwise, there a policy already.
Yes, my lord, because earlier the husband was transferred to the Gauhati, my lord.
Where is that policy?
But policy, my lord, unemployment will apprise, my lord, because we have not
You have
found
got
in the
hold-
website.
You have got hold of a draft policy, you can't get the
In
actual.
website, my lord, I have found that only.
Website.
Whether it is finalized or not, my lord, I am not aware. Because
Yes.
earlier, husband of the petitioner was transferred from AMC to GMC. But on the basis of that, my lord,
So, Mr. Polita, you have to show us what policies and circulars and notifications are currently available. You have to, these are available in,
that is why I have searched, my lord, but I have not found.
No, it
My
is
lord,
available.
claim will apprise, my lord.
it will be available because you have to, you are a government servant, you have been transferred to a different place in the same capacity. Same capacity, your status has not been affected, salary paid. Your only grievance is that according to you, that is not a place where you should work, there is more work here, your husband is here, you have other, all these things are there. But unless there is a policy by the government, your learning, I don't know whether it is able to help you good.
And secondly, my lord, India is speaking on the mainly two grounds. One is that, my lord, there is no available vacancy to accommodate the petitioner. And it is observed that, my lord, her transfer petition will be considered.
Where is your husband working?
AMCH,
And where are you transferred?
SMCH,
You are working where now?
AMCH.
AMCA.
And also, the person,
Why are you transferring her to SMCA? You are saying that there is no vacancy available.
Yes, in AMC.
But she's working there.
No, my lord. There was another person was transferred in her place, and that person has already joined. Respond number
But
5, my lord.
that person, my lord, holding the post of professor, my lord, kindly say, my lord, that
She has
person
joined.
has already.
My lord, your lordship may issue notice, my lord. I will file affidavit, my lord.
File affidavit, but meanwhile, what happens to the transfer order?
Because there is no vacancy at present and AMCS, my lord.
The person,
The respond number 5 has already
We
joined.
are asking the question that where should the transfer order?
Yes, my lord.
Thinking that it is in public interest or public service, but
Yes,
there are certain issues which have been raised by the petitioner.
yes, my lord.
Spouse posting, etc., etc. Now, these are things should have considered and disposed of the representation,
Yes, that has been
leaving
disposed of.
the matter to rest.
That has been disposed of, my lord.
It
And
has
the
been
person-
disposed of,
Annex 16, page 70.
but this availability of a circular or not is not there.
It is not there, my lord.
Then,
My lord, in his petition also, he has not enclosed any circular, my lord. On that.
right, we are asking you if there is any circular.
Lord, I have to obtain instruction. I have to file affidavit, my lord.
File your affidavit.
and the, my
Yes,
lord,
my lord.
the order, they have stated that no post of associate professor is vacant. The person who has been posted against me, my lord, that person is holding post of professor, not the associate professor. And I am holding the post of associate professor.
You are holding associate professor, but you are in charge professor.
No, my lord. I am the associate professor, but
Then how are you transferring a professor to the post of associate professor?
No, he has been transferred to the post of associate professor.
So she has been transferred, but her reliever appears to be a professor.
But in post title at page 5, my lord, respond number 6, it seems that she is associate professor.
So she is associate professor, but she has been transferred on promotion.
earlier she was promoted on 24th September 2025 while she was working at SMC.
And she's already a professor.
Already a professor.
She's already.
First transfer order.
Transfer order, lordship, may kindly.
Then why have you indicated that she's an associate professor in the post title?
Because, my lord, page 27 in the earlier transfer order, they have shown her as a, my lord, associate professor. Page 27.
Then she's an associate professor.
Yes, my lord, she is associate professor.
But this notification says, my lord,
This notification, we find out which is the current.
Because she has been transferred as associate professor, my lord. Impune transfer order at page 27. So regarding that posting issue, my lord, I don't think there is any issue. But now the main issue is that, my lord, there is no available vacancy. What the speaking order says, my lord, and it also, my lord, says that, my lord, her transfer petition will be considered in the next DPC. That paragraph, my lord, last but 3 paragraph, my lord.
When is the next division?
The government may consider the transfer petition of Dr. Jolly Rava in the next DPC meeting based on administrative necessity and availability of vacancies. My lord, otherwise, my lord, the transfer order or speaking order, my lord, it is there is no any malafide or any violation of any statutory provision. And the petitioner, my lord, she is in Dibrugarh for last several years, my lord. So transferring her transfer is a
Yes, shows that there is some transfer policy in place regarding private sector.
The draft transfer policy, which was, my lord, uploaded in the year 2015, whether it is finalized or not, my learned friend will let him apprise, my lord, the fundamental. Any day, my lord. And, my lord, whether she, and this, I have stated in
You get it
paragraph
by
2, my
Monday, tell us whether this policy is finalized or not.
My lord, instead of that, my lord, late notice be issued, I will file a detailed affidavit because that is not the only issue, my lord. Regarding the
And
petition, my lord, I will file a
See, you file a detailed affidavit, there will be a prayer for a stay. Now the
my lord,
question
stay
is,
on what count, my lord? There is apparently, my lord,
therefore we are asking,
Yes.
get your instructions whether there is any certainty with this policy, whether it has
yes,
been
my lord, your
finalized,
lordship
not
may indicate that
finalized.
I will obtain the instruction.
Obtain instructions, tell us by
and
Monday.
regarding, my lord, that whether she is holding the post of professor or not, that is also.
No,
fine.
we
No,
will
that is
go
not
by
the
the
issue.
impugned order.
But,
You
my
go
lord,
by the impugned order. Impugned order says she is an associate professor.
I have in my petition in paragraph, kindly see, my lord, in paragraph 2, my lord, paragraph 3, I have stated that she is holding the post of professor.
But you have varied her as a associate professor.
Earlier, my lord, that
And she has
information,
been transferred as an associate professor, my lord. Page 27.
how a professor can be transferred in the post of associate professor?
Because sometimes, my lord, some person forgo their promotion.
Person cannot be demoted, my lord.
No, they can forgo their promotion.
Already promoted. Already. Yes, 2025 itself, September.
Unless you give us some ground, we can't give you a stay. Only on the ground that your husband is working there. There are
My
no
lord, spouse policy, my lord,
Where is the spouse policy?
spouse policy, my lord, they are the better, my lord, the
All right, you
authority, my lord.
inform us on Monday. Matter be taken up on Monday, enabling the standing council. There is any policy, force in respect of transfer and posting, where both husband and wife are employees of same department.
And, my lord, while passing the impugned speaking order, my lord, so-called, my lord, let him produce the record, my lord, on one basis, my lord, whether they have collected any report from the MCH or not.
What report is required?
My lord, whether
They have transferred you with public service. They
Yes,
say
my
that
lord.
you are there, your services are wanted at
My lord,
place.
Commissioner and Secretary is at Gauhati, but he must have obtained a report, my lord, from the
Then you have to
MCH.
allege malice. Allege malice against the respondents. Then there is, according to you, there is no information. Vote is not
No,
vote is not,
I-
cannot be treated in the same forum as information disclosure authority. That will
As
call
I
the
have
files
been-
and give it to you, see whether the grounds are there or not. You make out a case.
Yes, my lord, I have already taken a plea, my lord, that I have to.
You have taken a plea, they will respond. But your plea, prima facie, must satisfy that yes, there are no grounds for transfer, or the transfer is not in bona fide reasons. You are a government servant. Is it a case that by the policies of transfer or the service conditions do not permit you to go out of the district? No. Then is it a case that you have not completed 2 years or 3 years? No.
No, I am only on the, basically, only on the that spouse
That
posting
spouse
policy.
posting, according to you, you have not been able to lay your hands on any policy, it's up to the department to decide.
Yes, madam. Let him produce, madam,
Let
that
him
whether-
produce that.
And madam, also, madam, that whether she is holding the post of officer or not.
How does it matter?
Kindly,
How does it matter?
because madam, they have said in their Indian order, they have stated
It is
that
up
no-
to the private respondent to decide whether she wants to be transferred as an associate professor when she is professor. How does it matter to you? You are concerned
Because,
with
madam,
your transfer.
madam, not the case that she has refused the promotion. She has already promoted.
You are before the court challenging your transfer
Yes.
from Dibrugarh to Silchar. It is not your case that in Silchar there is no post of associate professor. No. It is not your case that the associate professor post is not in the department that you are specialized in. It is not your case that under the service conditions you are not required to be transferred at all. It is just a transfer from one place of posting to another. So, unless you show that the transfer is not in bona fide reasons, you are bound by your contract of service.
Yes.
Just on Monday, Mr. Bora, you see what circulars are available.
Yes. Madam, till Monday, madam.
No. Consider your prayer on Monday
Yes.
for interview. Let there be something.
Obliged.
Just on Monday. You give him an extra copy today itself.
Obliged.
Yes.
You know that as per the council's, my lord, the service upon the respondents have been complete, my lord. They have entered appearance apart from respondent number 9, 16, 17, 20 and 20.
It's deemed to be complete as per the
Yes.
laws in the report. As per laws in the court order, service on
Service is complete.
respondents 9, 16, 17, 20 and 24
24.
have been shown to have received by the concerned respondents. Cards have been received. Service on the respondent. So here appears for
Respondent number 4 to 8, 10 to 15,
appears for respondents 4 to 8, 10 to 15,
19,
19,
21, 22, 23,
51 to 23,
25 to 31.
25 to 30. What file your response?
Lords.
Submits that will be granted. It's time to file this counter evidence. We may discuss matter again after 3 weeks.
Paper date, madam.
Let him file it first, then you make a mention.
Yes.
That this IA is filed, my lord, to impede as a party respondent, my lord, first wife, my lord, she has already married another person.
First wife.
Yes, ma'am. She was there, but subsequently she has left, my lord, the house of the husband and married another person. Court observed it. That's
You
why-
are the second wife.
Yes, my second wife.
You are not entitled to pension at all.
No, my lord, first wife already left, my lord. I have mentioned.
Then why are you saying first wife, second wife?
Oh, now, yes, ma'am. Legally not.
Is there a divorce?
No.
Then,
No.
then legally she is the first wife.
My lord,
Continues to be the
They
first
have observed, my lord, here, they are copy, my lord, that after the death of the husband of the petitioner, how can he or pass, take that order from the divorce of the, already she has married, I have annexed all papers. I have
Not-
annexed. There is certificate annexed.
And notarized.
in the document in the department, in the service, whose name is there? Nominee?
First wife.
First wife,
He has not made her a party now with IA. He is
third counsel for party, IA. The each does counsel for party. It's filing the IA seeking improvement of five, 8. Has it expired?
yes.
Experiment. Already she is along with Procedural Rafa.
So, what do you- wife, okay. Is the pension in favor of number 4?
No, no.
Therefore,
There was no
department has got benefits of them.
Of the first wife that is going to be increased.
You have released.
Not yet.
No.
That's what I'm saying. Then that's okay, that way. This one. Why mention necessary party? By status for medicines. Besides the
Gudasuri Gudasuri
petitioner, also married partner. Since it is a question of
No, no, no.
Huh?
Provincial Rafa is
Second.
saying first wife's husband now. Dizzy's husband was named
Indo.
yes, Monindra Rafa. Right? File amendment title. Stop.
May I please, Your Lordship? This subsequent to Your Lordship, petitioner died, legal heir of the deceased.
When did your husband?
Husband, Lordship.
When did he die?
29/10/2025, 25, Lordship. This number 8, Lordship.
What is the limitation?
Limitation, Lordship, 90 days. Now, I have filed for 136 days.
Huh?
136 days. Knowledge was only 6/3/2026, Lordship.
How?
Lordship, I have no phone number of the legal heirs of the.
No, it is not your knowledge. It is the knowledge of the legal heirs. They are staying with the deceased husband.
Lordship.
Then how did they not inform you?
I have my phone number is not
Your phone number, but they filed a petition.
Yes.
Where have you explained all that?
Page number, Lordship. I have knowledge about the page number, Lordship. 4, Lordship. Paragraph number 2.
You have to, this application is sworn by whom? By the
Wife, son.
Some explanation is called for why they did not inform you. Say that you have come to know only on 6/3.
6/3.
Why on 6/3? Why not immediately thereafter, within 90 days?
That's it. After the 2014, 5, 2025, the last listed this matter. 14, 5, 2025.
Some explanation is required. Yes, madam. Any objection?
LMP controller.
Heard, Mr. K.R. Bora.
I have a prayer, my lord.
What is that?
My lord, matter can maybe sent for mediation. This type of case.
First, let us complete legal age. The former. Yes. You are appearing for the respondents.
3, 4.
3, 4. It says Purva appears for respondent 1. Husband of applicants number 1 and father of applicants 2 and 3 was serving under the respondent number 3. Where was he working? Respondent 3. He was working as what?
As port gate.
Serving the respondent 3. He was terminated initially.
Terminated and reinstated by the
Reinstated. He was terminated and subsequently reinstated on 13/9/24. However, he is back with us in seniority with effect from 17/10/2003. Stop. File the requisition and same is pending disposal with this court. Petitioner, however, expired on 29/10/2023. So, representing the respondent was not informed about the death of Late Sachin Doctor. Submission of the council that the village site these contact details were not, perhaps not there. They were also not well versed with the procedure prescribed for substituting alias. Instructions he felt necessary in respect of the pending litigation that he informed that so council of the applicants need to be informed about 6/3/6. Claims made by the petitioner and allowed the bank to collect marital benefits which are received or to be received by the for substitution. Submissions made. Seen that claims made by the respect of his activities, seniority. Back wages at least are considered to be awarded, are required to be awarded, considered required to be awarded, considered by the court and required to be awarded respondents, then substantial financial benefit will this court accepts the submissions made by the counsel for the application. Substitution. Slightly before the next step. Can you write when you order past in high so and so? Respondents have filed their counter, no? Respondents, so file their counter. So,
I'll have. If I file for staggering name of the accountant general, because their prayer is for compassionate family pension.
prayer is for
Payment of compassionate family pension. That is not dealt by accountant.
you want deletion of your name.
Yes, but you do not have role because their prayer is by prayer. They have compassionate family pension.
Another, I have not now justified, but their authority, I think this authority is required for AG. But the appointing authority or the department, they can sanction, but send to the AG for their verification.
What is your claim in the report?
My lord, I am governed by the NPS, my lord. My husband died, so a scheme is there, contributory family pension. So I applied for that. That was not given. That is why I grievance. And now I have made the director of pension also as well as the AG also. Now from AG says that they have no roles and their name should be struggle. At this stage, but I have not given any objection. But there is a authority is taken. Authority is required from AG minor. If that's so, so their role is there. But at present, that notification I cannot give.
I did.
Yes, Malota, after due, if
Mr. C. Barwada. Yeah.
Perfect.
869. Application filed by the from the area of
Mention in paragraph 3.
Of the parties may file their objection with any, right?
Unless
So, quite there for the litigation. 1 and 2.
Petitioner Lordship may kindly produce the order of suspension at page 26, Lordship. Your Lordship, petitioner was placed under suspension with effect from the last paragraph. Last paragraph,
Page
page 26.
26.
Yes, Lordship. Petitioner was placed under suspension with effect from 1910-2002. And since then, is under suspension, Lordship. Thereafter, Lordship, no proposed Lordship and no memorandum of charges or no charge sheet has been filed within the period of 90 days. Which is pending in other judges. So that we have done.
Are these rules applicable? 64 rules are applicable. Government. 64 rules are made for government servants. They are not government servants.
I have received instruction, but I will file affidavit.
File. Let the affidavit be filed. Mr. T. Som is for the council. Mr. SPI resides in responding. So petition is agreed. The date
19/2.
19
2025.
19 to 2025.
No, Lordship.
Huh?
Not transfer, Lordship.
I'm sorry,
Page 20,
suspension.
26,
Suspension.
Like he was with effect, no specific date was mentioned in that letter. Page 26. But with effect from 1910-2024 in para 3, third para, Lordship. Therefore, starting from therefore, there we can
No,
find.
what is the date of this order?
92, madam. 92.
No, okay, below the name it is there.
It was for
No
the
date was
No,
mentioned there.
below the name it is there.
order with me, madam.
19
92.
19. And by suspended, placed under suspension with effect from 1910, 24. Since the date of suspension, kept under suspension. Still Sutia on the other hand. Consider next again after 3 weeks, enabling the respondents to file their affidavit. Yes.
Lordship has given me the order dated by your lordship.
order is applicable to my case. Because your lordship, so that
What is your case in the first?
first of your case, my case is your lordship. We are appointed 1994 in a vacant and sanctioned post. And all the conditions contained in 2013 notification.
Where is your appointment order?
Yes, Lord. We find at page 28. Next one.
Yes.
Sir, these are the appointment appointed the work with Gauhati for a period of 3 in the scale pay of province. As per this advocate, get 15,390. And these are the person appointed since 15,394. They are going to work. And some of the persons during the life period of service, they are expired. And page 46, your lordship will find. After death of a incumbent, some compensation appointment also has been made. And some of the has been appointed in 97 also. After satisfactory verification, that is page 49. Whatever is my claim that our service has not been regularized for the reason that we are depriving from pension and other benefits.
You are retired.
Some of them retired now during the pendency last, but no pension, no disability. But GPF is also there. So in view of the office memorandum by Department of Promotional Secretary, got over some pension and given public health department, we are entitled for pension and benefit.
Where is that?
That page is page 50.
50?
Oh. Yes.
How are you a government servant? Show us. What
Yes,
are the
Lordship.
conditions necessary for being a government
Yes,
servant?
yes. Even temporary appointment and works are also there. The lordship will find.
What are the criteria?
Criteria, lordship will find page 72.
72. Yes.
Of the Upanda's judgment, the division bench, as well as other grievance judgment. Those who are working in sanctioned post till 2006, Madhavi, they have to be elected. If they were continued in sanctioned
As per Upendas.
Upenda, 53 Madhavi.
Upendas says
Yes.
that these persons are not entitled to regularization.
No, in sanction or not sanction.
Sanction, not sanction, whatever, you are not
No,
regularized.
no,
Otherwise, see, if it is a sanction post,
yes,
you are under which department?
public health department.
Public health. Show us from the service rules.
Yes.
That these posts are included in the cadre.
Your lordship will find page 72.
72.
Yes.
72 is the list.
List. Your
Please show
lordship
us from the service rules that if it is a sanction post, it must be a part of the cadre of the department.
post has been created 1992.
So creation is different. Creation can be for anything.
Yes.
Posts, supernumerary posts are created to accommodate persons who are required to be regularized for a particular period of time. You are claiming the benefit of a circular. Say that temporary government servants.
Not only that also, but 2013 circular also covered. Those who are working since 1994 to 2006, not covered by court judgment, interim order, tribunal judgment.
Where is that circular?
That circular 2013.
Page number?
Yes, Lord. Fine. Page, Your Lordship, 58.
Dating what?
Yes, Lordship. Regulation of service of work search. I'm reading your Lordship. Regulation of service work search, master rule, and similarly placed workers in pursuance to the order of the Honorable of India in 10/4/2014 in 2006 in state of Karnataka, Kumadevi, read with orders of the state of Karnataka as a party, Proceeding and Fluency. And in pursuance to the officers of Honorable Gauhati High Court order dated 27/30 in which case number 22, cabinet issued memorandum stating that regularization of service of the workers, master rule, etc. similarly placed workers can be undertaken by the state government. All the government department officers were requested to follow the decision of the state government will now like to take up the one-time measure for the regularization of those workers as referred in paragraph 53 of the orders in the Umadb case provided ML Kesari case, whereby exception was carved out to regularize the employees who fulfill the following three conditions: who have been working continuously for 10 years or more as on 10/4/2006 in the death of passing of the judgment of Umadb case without benefit protection of the interim order of any court or tribunal, who have been engaged against a sanctioned vacant post, who have requisite qualification to hold the post. It is therefore necessary to undertake one-time exercise to regularize the workers, master so and so.
Pursuant to this, what step was taken?
Pursuant to this, they have taken that the recommendation has been made and they have issued certain instructions, and their GPF account has been opened subsequently, and service book also has been taken up. Pay revision of pay scale also given, page 75, your lordship will find, and service book page 76. And the communication from one department to other department, government to the secretary, director of health, etc. are going on. But no concrete result. Last one, they have filed. They have issued a letter, your lordship, page 71. Start from 70. Development Commissioner, Assam Hill Area Department Complaint District to be Principal Secretary, Karbi Anong, District Council Principal Secretary, North Kasa Hills. Matter related to regulation service of workers, master workers, similarly placed workers regarding Finance Record Women 2013. With reference to the subject circular, I am directed to forward here the copy of the letter shown to receive from the Finance EC2 Department, who speak itself, and to request you to kindly furnish the information as sought for this department urgently today for onward submission of the same to the Finance Department. And with reference to subject circular above, next page 71, to submit here with the matter relating to service of the worker. And these are the list has been given. 72, your lordship. Yes. The creation of post, so and so, and their length of service, number of service. So
What has happened? What has happened to the affidavits? No affidavits.
Fine.
We filed, but what is your case? They're claiming for pension.
It is covered by your lordship, sir.
Which judgment?
The one that my lord I had faced last time.
which learned, my learned senior is saying is not applicable. But my learned senior has not demonstrated how it is not applicable.
What
Because
is the judgment?
this one.
You're working in what master role?
Master box of Khalas.
What work as Khalas?
There are 15 or lordship will see.
Yes. That is what we asked you first. That the division bench judgment negated the claims of pension.
The judge,
Not this judgment, Upendra's.
when the judgment your lordship will find, here are the two parts. When the judgment has been paragraph (21), yes, 21. I read your lordship. Lastly, respondent cited decision of the Supreme Court in Nihal 23rd of Punjab 2013 contingent even after one meeting. Supreme Court has directed for regulation even by creating although the employees were not working on sanction posts. But these decisions are different acts and court itself held that ratio of decision commodity was not applicable to them. Case of Nihal Singh state of
You read paragraph 23.
20, yes. 20 and 20. Yes. For the reason we have noted, that situation indication master workshop worker, casual worker are not entitled for regularization for the service, considered such as pension, etc. Because of the foregoing to the 21-year old, 22-year lordship activity. Hex situation 22 and 20. 22-year lordship time. It is, however, heartening to learn that state government has agreed not to terminate the master rule workshops and similarly place employees working in last more than 10 years, not in sanction posts. Those who are not in sanction posts, they will not be terminated. If a lordship take into consideration if they are in sanction posts, situation will be different. Kindly see a lordship, till their normal retirement, except on disciplinary ground on the ground of criminal offences. State government has also agreed to enlist such employees in health and accidental death insurance scheme, which will be prepared for the consultation of the state cabinet. We appreciate the positive stand of the state government taking a welfare measure for the benefit of the security of the employee. In question, we accordingly direct state government to implement the measure without further delay. Besides this, in the light of the decision of the Supreme Court instead of Punjab Jagdeep Singh so and so, direct the government to pay minimum pay scale master workers in similarly placed employees working in last more than 10 years, not in sanction posts. But those who are in sanction posts, we are carrying. And we, because we say that our post has been created in 1994, even though you are not to assume that we are not in
Where is
sanction
the
posts.
creation of your posts? Where is the order which says you are appointed in sanction posts?
Yes, yes, Lordship, that is there. Last, from the they have appointment letter they have not stated, but to this list they have submitted, they have said that post has been created. Created means it is sanctioned. Vacant post in the year 1994. Now, to that extent, they have to give an affidavit whether these are the sanctioned posts or not. And your lordship, next item, your lordship, kindly see another important part, your lordship. My item number 18, your lordship, kindly see. appointment.
No, no, we'll go one by one.
Yes.
Like you file your affidavits. Are you intending to file
We'll
affidavits?
file.
Right. The claim of the petitioners are that they have been rendering their services as master role workers.
Yes. Workers oblique master.
Work charge of master role. So the department of
Public
What
health
is-
engineer.
what is that? Public
Public health engineer.
Public health. Right. I mean, gets sanctioned. Claims for regularization. For regularization of services. Specific order. Submits. You're still working or retired?
Yes, still working.
Yes. That the petition is still serving. Therefore, services ought to be regularized. Benefits of regular service. Steps covered. Not intended. Petitioners have been rendering their services in sanctioned posts. Therefore, permission the permitted to file their affidavit in matter to be listed thereafter. Mr. C. Borua used for accounting method. C. Borua for 1 and 7 is temporary for 3 and yes. List after 2 weeks.
Still in your tip, when the judgment is still pending, it could be different of the when the case the pending before the Supreme Court. Next start I have heard about it, but judgment has not been delivered. Hearing has been completed.
Hearing completed.
Completed. But judgment has not been come out.
We have the particulars.
I have heard about one of the cases here from of the person.
No, do you have the case particulars?
Yes, my friend, one of the counselor was appearing there.
Right, you furnish the particulars. SLP numbers.
Yes, yes.
Date, etc.
What?
Everything.
What?
Our instruction is everything.
Instructions are awaited. Mr. Padgiri,
allow that's not a matter of important mediation. Some cases settlement.
Mr. K.R. Padgiri submits that the matter be referred to mediation. Mr. Mukhari on the other end, representing
7, 8 and 9.
respondent 7, 8 and 9 submits that his instructions are not complete, but he does not object to the matter. Similar submissions are made by the respective counsel, Mr.
A Banerjee 1 and 4.
A. Banerjee appearing for 1 and 4 and Mr. C. Barua for 5. List. The matter be referred to for mediation. (22nd of April). Parties will appear before the High Court Mediation Center.
Tilapia,
21.
21.
Similar prayer. M. Das for PWD. C. Barua for accounting and S. Barua for referred for mediation the same day.
All right.
We have filed our affidavit yesterday. And the affidavit found.
Mr. S. for the petitioner and Ms. M. Das for the partner PWD. The affidavits have been filed yesterday. You have received copies?
Yes.
For the new matter. Still, registry will connect the evidence stated to be filed by the respondent and list the matter up. Petitioner may file their joinder if so. MS so is for respondent.
Okay.
One part I am not challenging regarding.
Whatever you are challenging, there is a forum for review. Go and file a review. The authority. Huh?
That agreed matter action of the or non-string of appointment order. They preferred appeal.
You preferred an appeal.
My,
that was allowed.
that is allowed.
You are. Where is the order of the appellate authority?
Case 34, Mari.
It is the direction.
The Lord will find at case 38, Mari.
Direction. There is no direction.
There
That you
is no
should be
direction.
appointed.
They'll go for a fresh selection.
My humble submission is that this select list is valid till the picking order is passed.
Where is the select list? Where is the select list?
My lord, case 20 men.
Yes, it can be valid for 1 year.
But the matter is under substance for this court as well as before the appellate.
No, this court because you have come.
Stay was granted, my lord.
It may be, but unless there is a specific direction, you file an appeal. The appeal, in the appeal, there is no direction that you should be reinstated. You are not the selected candidate.
I am selected candidate, my
Huh?
I am selected.
Then why did you file an appeal?
Case 26 mechanically. Serial number 11.
Yes.
I am the second highest scorer, man. So after setting aside the appointment of the highest stopper,
Serial number 11.
11 man, I am elevated to the first position. Considering this constitutional order should be passed. That is not
Therefore, you should file a review. File a review. That the appellate court did not consider these aspects. Yes, respondents? Says the select list is there, why go for another selection? Select it, second man. Revenue?
Ma'am, there is no concept of waiting list. Sir. Immediately in the select list.
the base of the record, the selection list is not challenged. Either in the appellate authority or
Select list, this is meant for only one post, isn't it?
yes, man.
One post.
One.
The moment the person is selected, the select list is ready to go on.
Earlier, while I approached the Honorable Court, the direction to appear for appeal, the matter was select list was stay. So while the matter is pending before the appellate authority, I think it is valid. And during this validity, the selection of highest scorer has been set aside. So I am automatically elevated to first position.
Are you responsible? Setting aside the appointment of private respondent.
There is no private respondent.
Who is the person whose appointment was set aside?
Anwar.
Taking the appointment of one Anwar Hussain, who was appointed as Dr. Khan. Tampupara.
Yes.
Now. See. Strict commissioner, red for second highest as per the selected. Was selected was one thing. That makes the petitioner the second highest.
proceeding, pre-selection. Proceed for pre-selection. Submit that. Garrison should be done with it. List again after 2 weeks. The respondent will complete instructions and file in the year.
Till then, my lord, no selection will be.
In the selection, you come, you get to know there has to be an advertisement. Notification. Very clear. Petitioner before ultimately is a great for employment serving as helper. And she has already retired from service. This case knowledge the only respondent or poor file the affidavit. Matter was informed mediation. Then period order the. Yeah. Has already served 26 years as helper. In what capacity? As helper. As helper? Yes. Great for him. Where is the employer? Where is the appointment order? Appointment order is also find page 19 onwards. 19. First 27 May 1991. Number 4. Page 20. Then the order was extended from time to time by 16. List was prepared. Page 1 by appropriate period of 1st of March 2005 for payment of minimum scale of payment. Then there was now action was taken that report minimum scale not granted. Not granted. Not granted. Not granted. Why? Why they have not filed any affidavit? Minimum scale of pay, why not granted?
As per our affidavit, petitioner had served for only 2 years and 5 months.
How they assess
His
my lord?
lordship, the annexure number 90. Sir, his service was extended for 154 days, and in another annexure, page number 21 for 91 days. It is not continuous. And in page 23, 91 days, page 25, 60 days, page 27.
No, where is the requirement that you have to serve for how many years? 10 years.
Lordship,
No.
it's just from time to time, it is extended. It's a temporary post.
But the name in the list, her name is there.
Yes, page 45, kindly see my little period of service.
Period of 6 months.
Page
as per
45.
order.
For a moment. Of my
Says he's put in 26 years.
record says
26 years.
yes. Middle column serial number 5.
Record mal page 45 prepared by the undersecretary to the government of Assam. Respond for Justice Department. General manager, not of. Yes, file with my giving comment. Page number 59. Because the petitioner is terminated on her attaining the age of Where is that judgment of Upendas? Latest decision of the Honorable Supreme Court bouncing case. Some service of the petitioner, person who continues her service, be regularized for the purpose of giving determined. Then you'll have to bypass Upendas. Upendas judgment is a clear authority to say that you're not entitled for regularization. But the Memorandum 13, my senior is like 17. I'm entitled under that. Whatever you are entitled, but the fact is that there is a judgment of a what charge master or etc. are not entitled to. Offender's case is also before you know. The outcome is that what you want. Till then, my lord, the respondent may also file their affidavit. File. Only the respondent 4 may giving false statement. Petitioner has served only for 2 years. No. We can dispose of the matter in terms of offenders. Offenders also says, my lord, the petitioner is to pay minimum pay scale. That was also not granted. So you give us the judgment, we'll lose it. Or if you want to await the outcome of offenders, because on one hand, you are claiming the benefit of offenders. On the other hand, you want to await the outcome of offenders. Stands. Which one do you want to take? Let them file their affidavit. They've already filed, but if they don't file, state government might. So if they don't file, then are we to wait for eternity? If they don't file, no. We are not supposed to invite them to file. Should notice. Not to file, it is their call. Tell us what you want. But then you'll also dispose it of my lord, the directing response to pay the minimum pay. So you give us the judgment. My lord, the record my lord, page 45, 44, 43 onwards. The approved list, my lord, where my name is in. The judgment is offenders. This is not, right now I am. You bring it, I'll close it. Friday, not Friday, after vacation. Matter be listed immediately after vacation. From the Supreme Court was referred. Where is that judgment?
Yes, it's in the record, annexure C1 in the lead matter.
Which is the lead matter?
I'm referring to Shyam Sundar Kalita, my lord, subject to what my learned senior counsel. Was with petition 5823 of 25.
5823.
Item 28.
Paragraph 44. You have to tell us the name.
My lord, the name was Employees PF Organization versus Sunil Kumar B. Sunil Kumar B, my lord. He is the last time for
Page 100. Paragraph 44. Page 145.
Of which writ petition? Which writ petition?
5823.
Item number 20.
That is not available.
My lord may indicate the one my lord has, we'll pull out that page.
For judgment, 111.
Yes.
Page 156. Pensioners did not exercise options. They exercised or they did not exercise?
Exercise.
Exercise.
After the Supreme Court judgment, after this judgment.
After the judgment and within the period which was permitted. Okay.
Then Lord, you are called upon to deposit the amount and deposited those amount.
Yes.
Five eight two three.
6075. Yes. 5823.
Yes, 5823.
Okay. Referring to para 44.
1 5. Start from 100.
Now, in terms of judgment, you had exercised the options.
Yes. We exercise this option. We are called upon to deposit the amount. We have deposited this amount. Thereafter, the pensions were granted to us, and subsequently, all on a sudden was stopped.
Why was it stopped?
There was no such reason assigned, but that was pertinent to the order dated 18/1/2025, which I have annexed here.
110. 10.
Paragraph number 2, eligibility for pension on higher wage cases would be determined on the basis of the extent of trust rules of the exempted establishment, consonance with the direction of the Honorable Supreme Court in Sunil Kumar case. Further, in case the trust rules amended post decision dated 4/11/2022 in Sunil Kumar case, the application of the members of trustee may not be considered. What they want to say, our case will be absolutely guided by our trust rules. If the trust rule does not provide these things, we are not entitled. It is the assignment substance of the contention. And this order was essayed in the defined high court. All these high court will not set aside this order.
So what is the ground for you to challenge this order? What grounds are you seeking an interference?
Now, Lord Cooper, paragraph 11, 4 is concerned of pension rules. Pension rules
1995.
PFI.
Now you tell us the name of the, under what rules?
Employees PF Act,
Employees PF Act.
Employees Provident Fund and Miscellaneous Provisions Act 1952. Now let's come to section 6A.
6A.
6A of the Act. Employees Pension Scheme. The central government may by notification in the official gazette framed a scheme to be called Employees Pension Scheme for the purpose of providing for superannuation pension, retiring pension, permanent and total disablement pension to the employees of the establishment or class of establishment to which this act applies. And now the widow or widow's pension, children pensions, or orphan pension payable beneficiaries to such employees. Now, in terms of this section, Miller, a rule was framed. This rule is called as Employees Pension Rules Pension Scheme 1995. That you will find this book itself, Miller, at page
Employees Pension Scheme 1995.
1995.
You are referring to Rule 11.
Yes. 11(4). Pensionable salary, let us pensionable salary shall be the average monthly pay drawn by any member, including the police rate basis. These are not very relevant. Straight away let Lordship come to 11(4). The existing member as on first day of September 2014 who are at the option of the employer and employee had been contributing salary exceeding 6,500 rupees per month may on fresh option exercise jointly by the employer and employee contribute on salary exceeding 15,000 rupees per month, then the pensionable salary the existing member who prefers such fresh action shall be based on the higher salary. That's what happening here. Section 6. Section 6 of the Act stipulates that the member, employer and employee shall contribute their contribution towards the provident fund at the rate of 10% or 12%. But there is a ceiling limit. That ceiling limit has been prescribed by the Provident Fund Scheme, paragraph 26. And this ceiling limit is increasing from time to time. And ultimately, this ceiling limit was made to the extent of rupees 15,000. Meaning thereby, the employee's contribution to the extent of 10% on the rupees 15,000 will be deposited to the provident fund. Similarly, the employer's contribution to the extent of rupees 15,000 will be deposited to the employee's provident fund, irrespective of the fact that whatever salary they draw. Now, this ceiling limit was lifted.
was lifted.
lifted. The year 2000, lifted in the year, last selling limit was lifted in the year 2014. Now, but one thing is that the employee concerned must exercise their option within 6 months from the date of notification.
Notification of lifting the ceiling.
Still lifting the ceiling.
What are the options available?
That is 11/4.
11/4.
4 of the pension scheme.
The option was lifted on first day of September 2014.
2004. And only 6 month time was granted to
For
exercise this
exercising
option.
options.
What
are the options to be exercised?
That is, your lordship, come to the proviso. Proviso provided that the aforesaid members have to contribute the rate of 1.6% of their salary exceeding 15,000 rupees as an additional contribution from and out of the contribution payable by the employee for each month under the provision of this Act or the rules made thereunder. Next proviso, provided further that the phrase option shall be exercised by the members within a period of 6 months from the last day of September 2014.
No, we are asking you what options are to be exercised. What are the options available?
Options contribute at a higher rate.
Higher rate.
That is, ceiling was 15,000. But one can exercise his option.
15,000 is the ceiling under which ordinarily it will be calculated and deposited.
Right.
But if the employee wants to contribute something more,
then he can exercise his option.
The option.
This option has to be exercised
within 6 months.
Within 6 months. Immediately, all these petitioners, before your lordship, they had not exercised their option.
Why?
Within a period of 6 months. Then, my lord, some of these similarly situated persons who had not exercised their option in a period of 6 months, they approached for defined high courts. And all these high court allowed their petition. Then the EFF, Provident Fund Authority, approved before the Supreme Court. And Supreme Court felt that no, all the High Court judgments were set aside by the Supreme Court. But some window period was given. Some additional period was granted by the Supreme Court that the person concerned who had not exercised their option, they may exercise their option. They may exercise their option in exercise of their power conferred under Article 142. That is what is in the paragraph 44 of this judgment. Then, my lord, in terms of this judgment of the Supreme Court, my lord, all the persons who had not exercised their option in due time, they have exercised, and we are some of them. And when we have exercised their option, our employer also agreed with the option. They have no objection, and thereafter was placed before the Provident Fund Authority. Then Provident Fund Authority accepted our option. After accepting our option, Provident Fund Authority asked us to deposit the amount, because we are to deposit the amount on the date of the creation of this Provident Fund scheme, pension scheme, which was created in the year 1995, 16/11/1995. From that date, we have to pay. So, we have deposited this amount. Actually, we have deposited this amount, then the Provident Fund Authority granted our pension on higher rates. All on a sudden, they have restricted this higher wage pension by stating inter alia that your trust rules, we have our trust rules,
Say something else.
say something else.
And you are bound by your trust rules.
We are bound by our trust.
Is there any finding by the apex court to that extent? Is there any finding by the apex court that these exercise, the exercise of the options in the extended period of time, however, will be subject to trust rules?
No, no. That is not. On the contrary, Miller defined. On the contrary, Miller defined high courts as held that no, they are not bound by the trust rule. They are bound by the act itself.
Now, this restraint, which has been ordered by the authorities across the country.
Yes.
So there are other petitions again pending before the different high courts.
Yes.
In respect of this.
Yes, yes. They have delivered this judgment also, and I have brought these judgments also. There are 3 judgments I have. One from Calcutta High Court, other from Madras High Court.
I show us from the provisions of the Act.
Yes, I will. Yeah, on
or
that.
the scheme. Your submission perhaps would be that these trusts are framed under the scheme.
Under the Act.
Under the Act.
Under the Act.
Under the Act.
That will prevail. That is our contention, and that is also stated in the Rules Act itself. For that purpose, your Lordship may kindly come to paragraph 27. 27 double A of the Provident Fund Scheme.
7 double.
Trust is only applicable when this establishment is exempted under section 17. 27 double A, all exemptions already granted to be granted hereinafter under section 12 of the Act or under paragraph 27A of the scheme shall be subject to the terms and conditions given in Appendix A. But now, Your Lordship, got it, Lordship?
Yes.
Now, Lordship, come to Appendix A. One 141 of the bank here.
Yes.
The clause 10. Any amendment to the scheme which is more beneficial to the employees than the existing rules of the establishment shall be made applicable to them automatically pending formal amendment of the rules of the trust. So whether your trust, whether you have amended your trust or not, that is immaterial. If the rule is there, any amendment is made in the act of the scheme, it will be applicable to the rule.
Where is that amendment brought in under the scheme?
Under this scheme.
Referring to clause 10.
10.
Of the appendix, it says that in case there is an amendment to the scheme beneficial to the employee, it is applicable automatically. Now, which is that amendment you are referring to under the scheme?
That is the pension scheme. Pension scheme as well as the provident fund scheme also.
Right.
Pension scheme 1995.
So,
Paragraph 11(4).
11.
Page 208. Existing member as on the first day of September 2014, who at the option of the employer and employee had been contributing on salary exceeding 6,500 rupees per month may on fresh option exercise jointly by the employer and employee continue to contribute salary exceeding 15,000 rupees per month and pensionable salary for the existing member who prefer for such option shall be based on the higher salary. Ceiling limit was changed from time to time. At one point of time, it was 6,500. Thereafter, it becomes 15,000. Then, Millard, by this insertion of 11 paragraph 4, now it is 15,000, and the person concerned who makes an option, then can be granted the higher.
So therefore, according to you, since the amendment to the scheme has given you an additional benefit, the respondent authority cannot restrain or curtail that benefit to say that your rules don't
Trust
provide.
rule does not permit.
Does not permit.
That
Then
is
in
the
terms
concern.
of appendix A, appendix 10,
In appendix A,
appendix A,
appendix A
once
of
there is this amendment brought to the scheme, it should be automatically applicable.
automatically. Right? Even Millard, in our draft rule also, sorry, our trust rule also this provision.
9 of the definition. Number 47.
47A.
Statutory provisions to have overriding effect. In absence of any specific provision in these rules, if any provision of these rules is less beneficial than the corresponding provisions of the Employees Provident Fund and Miscellaneous Provisions Act 1952 and the Employees Provident Fund Scheme 1952, when thereunder the later provision shall prevail. It is usually. This same paragraph, appendix 10, substance of this appendix 10, appendix A, 10, clause 10 has been incorporated.
What rules are this being referred to? What is the rules? What is the rule? In the absence of specific provisions in these, what rules?
These are trust.
Trust rules. Then perhaps 47B also.
Where any provisions of the rule conflicts with the provisions of PPF scheme 1952, the latter shall always be deemed to be prevailing.
Restraining the benefits.
Restraining the benefit as it does not contain in the trust.
No, it says the trust rules are amended post decision in Sunil Kumar. So amended to for detriment. They amended to what is it?
Now, what they want to say, after Sunil Kumar's judgment, the trust rule is amended, then it will not be considered.
Trust rules are amended.
PL
What bring what effect?
to have the pension on the higher wages. What they want to say, the eligibility of pension on higher wage cases should be determined on the basis of the extant trust rules of the exempted establishment, in consonance with the direction of the Honorable Supreme Court in Sunil Kumar's case. Further, in case the trust rules are amended, post decision dated 4/11/2022, on what date this Sunil Kumar's judgment was delivered. In Sunil Kumar case, the application of the members of such trust may not be considered. So if the trust rule is amended after this judgment, then this trust rule shall not be considered. If the trust rule contains this provision before the Sunil Kumar judgment, then it will be considered according to them. Now, now the Sunil Kumar judgment will reflect that. The Sunil Kumar judgment let us have a glance. At page 145, ratio.
149.
Paragraph 44, 145. Now, we accordingly hold and direct the provision contained in notification GSR number such and such dated 22nd August 2014 are legal and valid. So far as the present members of the fund are concerned, we have read down the certain provisions of the scheme as applicable to their cases.
Where is the GSR number?
GSR number
Where is the notification?
that is here, that is 11. Paragraph 11.
It says the provisions contained in the notification GSR number so and so. Is the notification available here?
Yes, madam. My lord, please have 94, page number 94. That's 609E. Page 94 is the Hindi version, 96 is where the English has been explained. That was the amendment to the pension scheme. Yes. Right. That if my lord may consider, my suggestion would be, my lord, Supreme Court had drawn a comparative table between the unamended and the amended provision.
Just one minute.
Yes.
14.
My lord, may have page 109, that comparative chart in the judgment of the Supreme Court. That illustrates the difference with the notification brought.
No, that differentiation with respect to 11.3 and 11.4.
Let us first
That is
see,
not- that
let
is
us
not- we are
first
not-
see what the scheme is brought in.
Yes.
Yes, that is what it is, what they have compared.
No.
All right. No
The
problem. No problem.
difference, yes, you can say differentiation will be between 11.3 and 11.4.
Yes, that's what I meant.
But that is not required. That is not required.
The notification is the amendment to the scheme.
I have a spiral binding notification.
So it is here, page 96.
What we see at 96, the bottom para 4, and they suggest the substitution. It says in the principal scheme in para 11, and then the substitutions are mentioned. I was only suggesting Supreme Court has extracted that at page 109. There's a comparative chart. That's all I was suggesting.
Follow. I will clear it.
Yes.
Paragraph 11. Now, prior to that, below what my learned friend wants to say, 109 page 2. Prior to that, below field was governed by paragraph 11 of this scheme. That paragraph below, there was no cut-off date for exercising your option. Now let us come to paragraph 44. Paragraph 44 of this judgment. Now 34, paragraph subpart 2. Amendment the pension scheme brought about by the notification dated 22nd August 2014 shall apply to the employees of the exempted establishment. We are the employees of the exempted establishment.
You are exempted because you have your own fund rules.
Yes, trust rules.
Trust rules.
That is provident fund rules created by a trust. Exempted establishment in the same manner as the employees of the regular establishment. So there is no distinction between the exempted employees and non-exempted employees. But here they want to bring a distinction. They want to say that you are covered by the provisions of the trust rules. Exempted. That is the basic difference. But Supreme Court has specifically stated there shall not be any distinction between the exempted employee and the non-exempted employee.
Now, the last line of this paragraph, 44.2, says the transfer of funds shall be in the manner as directed. Where was it directed? Which paragraph?
Exempted restaurant shall be manner we have already directed.
Where is it directed?
One of the arguments against their inclusion into the scheme by exercising option is that the purpose of contribution for exempted establishment have been kept separate coffers maintained by the trust created for such purpose and not with the authority specified under this act. Oh. Taking that factor into account, we are of the view that in order to be entitled the benefits of the pension fund, the employer and employee simultaneously with exercising option in terms of the order of this book shall also have to give an undertaking of transferring the employee's contribution at the stipulated maintained in the trust. Stipulated rate maintained by the trust, which shall be equivalent to and not lower than the sum which would have been transferable had such fund been maintained by the Provident Fund authorities. Such transfer shall take place immediately after exercise of such option within such period as may be directed by the administrators of the pension fund. That's what happened below. So far the
Yes.
so far the Provident Fund Act is concerned, so far the unexempted employees are concerned, there is a ceiling limit of provision, depositing Provident Fund. But so far the trust rule is concerned, there is no such ceiling limit. One can deposit the trust, deposit the Provident Fund to the extent of their salary, basic salary. But only 8.33% will be diverted to the pension fund, not the entire amount deposited in the trust fund below. So here, for that reason, the Honorable Supreme Court gave a direction, the amount which was deposited in the trust fund, that shall be transmitted to the Regional Provident Fund Commissioner for the purpose of having pension on higher wages.
Continue.
Let me start with the Provident Fund Act was enacted in the year 1952. Section 6 makes it obligatory the part of the employer and employee to contribute a certain amount, 10 to 12% of their basic wages, the Provident Fund. Now, a scheme was formulated in the year 1952. This scheme below, paragraph 26 of this scheme stipulates that there should have a ceiling limit on the contribution of the Provident Fund. And this ceiling limit varies from time to time. And at present, this ceiling limit is rupees 15,000. Now, this ceiling limit was made optional by inserting paragraph 26 subclause 6 that By exercising this selling option, one can deposit their provident fund contribution to the extent of the entire salary. That is the
extent of their,
entire salary. Entire salary. That was
what is the contribution to be made by the employee? And what is the employee contribution?
10 to 12%,
Of
depending
this,
on the,
either of 15,000 or of the entire salary.
either 15% or of the 15%.
And what about the employer? What is the employer contribution? Same.
That was the option, but both the parties should agree that they would contribute. This is the denial provisions. But so far the other special provision is concerned, there is an exemption. That exemption is granted under Section 17, the Provident Fund Act. By this exemption below, Section 17(1) states that any employer can frame their own provident fund scheme, but it should be more beneficial than the scheme as stipulated in the Act. Now, this scheme was formulated, about 13,000 schemes have been formulated throughout India, defined public sector undertaking. The basic essence of this scheme is that both the employer and employee will contribute their provident fund contribution to the extent of the whole salary. Whole salary. There is no such ceiling limit. The extent of the whole salary. But so far the pension scheme is concerned, employer's contribution to the extent of 8.33% will be diverted to the Regional Provident Fund Commissioner for the purpose of grant of pension. That is the mandate of Section 17(6). Now, Lordship has come to provision 17(1). Well, that we will find at page 40. The appropriate government may, by notification in the official gazette, subject to such condition as may be specified in the notification, exempt, whether prospectively or retrospectively, from the operation of all or any of the provisions of any schemes. Now, these are the, for the time being, let us keep it up. Now, straightway, let us come subsection 6. Subject to the provisions of subsection 1(c), the employer of an exempted establishment or an exempted employee of an establishment to which the provisions of this pension scheme apply, of the pension scheme, shall, notwithstanding to any exemption granted under subsection 1 or subsection 2, pay to the pension fund such portion of the employer's contribution to its provident fund within such time as in such manner as may be specified in the pension scheme. So, the employer, though is exempted from the Provident Fund Act, they are required to deposit certain amount of their contribution towards the pension fund. And that pension fund will be maintained by the Regional Provision Fund. Now, as per this pension rule, 8.33% was were to be disbursed towards the pension fund, and remaining amount will be deposited in the trust. 8.33% of the employer's contribution will be deposited to the provision, will be remitted to the employer's pension fund. That account is maintained by the regional provident fund commission, and other portions of the amount which has been deposited, which has been contributed by the employer, shall remain the trust board. This was the scheme. Now, the year 1996, pension scheme was amended. So, paragraph 11, paragraph 3 was inserted. By this insertion, both the employer and employee, if they are agreeable, they can deposit their amount, entire amount, towards the provident fund, towards the pension fund. That ceiling limit was lifted, was made optional. For that purpose, the R.C. Gupta's case is some relevant here. Let us start from paragraph 2. The facts lie in the short campus. Under 1952 Act, 10% or 12% of the basic wages, including the dearness allowances, etc., is required to be deposited in the provident fund account of an employee being the employer's share. The Act, as enacted in the year 1952, did not contain any provision for pension. Section 6 capital A, with which we are concerned, was inserted by an amendment with effect from 16/11/1995, providing for employees' pension schemes to be framed for the payment of pension to the retiring employees. The purpose of the pension fund was to be alia constituted by deposit of 8.33% of the employer's contribution under Section 6 of the Act. The pension scheme, which was framed to give effect of the provisions of Section 6 capital A, consists inter alia clause 11, which deals with the determination of the pensionable salary. Under clause 11.3 of the pension scheme, the maximum pensionable salary was limited to rupees 5,000, which was subsequently enhanced to rupees 6,500 per month, with effect from 10/8/2001. A couple of months after, the pension scheme was framed with effect from 16/11/1995. A proviso added to clause 11.3 with effect from 16/3/1996, permitting an option to the employer and employee for contribution of salary exceeding rupees 5,000 or 6,500 with effect from 10/8/10/2001 per month. 8.33% of such contribution on full salary was required to be remitted to the pension fund. Now, paragraph 3. The appellant employees on the eve of the retirement, that is sometime in the year 2005, took the plea that the proviso brought in by the amendment of 1996 was not within their knowledge, and therefore they may be given the benefit thereof, particularly when the employer's contribution under the Act has been actual salary and not on the basis of the ceiling limit, either rupees 5,000 or 6,500 per month, as the case may be. This plea was negated by the Provident Fund Authority on the ground that the proviso visualized a cutoff date for exercise of option, namely the date of commencement of the scheme or from the date of the salary exceeded ceiling limit of rupees 5,000 or 6,500 per month, as may be. As the request of the appellant's employee was subsequent to either of the said dates, the same cannot be acceded to. Agreed by the appellant's employees moved High Court under Article 226 of the Constitution. The learned single judge decided the writ petition in favor of the appellant employees, making it clear that the decision would not serve as a precedent for the future. The division bench reversed the said decision, upholding the view of the Provident Fund Authority that under the proviso of clause 11.3, the pension scheme, there is a cut-off date. We have heard the learned counsel for the parties. We have read and considered the orders of the High Court and the provisions of the Act Provident Fund Scheme, as well as the relevant provisions for the pension scheme. Clause 6, paragraph 6. Clause 11.3 of the pension scheme is in the following term. Now, 3. The maximum pensionable salary shall be limited to rupees 6,500 per month, provided that if at option of the employee contributing the paid salary exceeding rupees 6,500 and 500, rupees 6,500 per month from the date of commencement of this scheme, from the date of the salary exceeds rupees 6,500, whichever is later, and 8.33% share of the employer thereof remitted in the pension fund, and pensionable salary shall be based on such higher salary. That was inserted in 11.3. Reading the proviso, we find the reference to the date of the commencement of the scheme or the date on which the salary exceeds the ceiling limit are the dates from which the option exercise are to be reckoned with the calculation of the pensionable salary. The said dates are not cut-off dates. Here is the said dates are not cut-off dates to determine the eligibility of the employer-employees to indicate their options under the proviso to clause 11.3 of the pension scheme. Somewhat similar view that has been expressed by this court in the matter coming from Kerala High Court, wherein the special leave petition such and such filed by the Regional Provident Fund Commissioner was rejected by this court by order dated 31/3/2016. The beneficial scheme of, in our considered view, ought not to be allowed to be defeated by reference to the cut-off date, particularly in a situation where as in the present case, the employer had deposited 12% of the actual salary and not 12% of the ceiling limit of rupees 5,000 or 6,500, as the case may be. A further argument has been made on behalf of the Provident Fund Commissioner that the appellant employee had already exercised their option under para 26 of the Employees Provident Fund Scheme in the following terms. Now the paragraph 26 of the Provident Fund Scheme has put it, notwithstanding anything contained in this paragraph, an officer not below the rank of an Assistant Provident Fund Commissioner may, on joint request in writing of any employee of a factory or other establishment which this scheme applies, and his employers enroll such employees as a member or allow him to contribute more than 6,500 of his pay per month if he is already a member of the fund, and thereupon such employee shall be entitled to the benefit and such be and shall be subject to the conditions of the fund, provided that the employer gives an undertaking in writing that he shall pay the administrative charge and payable and shall comply with the statutory provisions. We do not see how the exercise of option under paragraph 26 of the Provident Fund scheme can be constituted to stop the employee from exercising a similar option under paragraph 11.3. If both the employer and employees opt for deposit against the actual salary and not the ceiling amount, exercise of option under paragraph 26 of the Provident Fund scheme is inevitable. Exercise of the option under paragraph 26 is necessary prerequisite of the exercise of the option under clause 11.3. The exercise of such option, therefore, would not foreclose the exercise of further option, clause 11.3 of the pension schemes, unless the circumstances warranting the such foreclosure as clearly indicated. Now, after this judgment, this clause 11 was amended and a provision of clause 11.4 was inserted.
What about maybe after these are
11.4. There's 11.4 of pension scheme. Here there is a cut-off date. Cut-off date 08.
6 months.
6 month cut-off date. You will find, so for clause 3, the maximum pensionable salary shall be limited to the 15,000 per month and the remaining portion deleted. Now, after deleting this portion, the clause 4 was inserted. The existing members, as on the first day of September 2014, who at the option of the employer and employee had been contributing on salary exceeding 6,500 rupees per month, may on fresh option to be exercised jointly by the employer and employee continue to contribute on salary existing 15,000. Now there is an 15,000 rupees per month and pensionable salary for the existing members who prefer such fresh option shall be based on the higher salary. Now the proviso, these are very important. So there are 3 provisos. Proviso that provided that the aforesaid members have to contribute at the rate of 1.16% of the salary exceeding 15,000 rupees as an additional contribution from and out of the contribution payable by the employees for each month under the provisions of this Act or the rules made thereunder. Second proviso is there. Provided further that fresh option shall be exercised by the members within a period of 6 months. Here below this cut-off date has been inserted. Now, earlier 11th it was not there. 6 months on the first day of September 2014. Provided also that the period specified in the second proviso may on sufficient cause being shown by the member be extended by the Regional Provident Fund Commissioner for a further period not exceeding 6 months. Next paragraph is provided also that if no option is exercised by the member within such period, including the extended period, it shall be deemed that the member has not opted contribution over the wage ceiling and the contribution of the pension fund made over the wage ceiling in respect of the members shall be diverted to the provident fund account of the members along with interest as declared under the employees provident fund scheme from the time to time. Now, so far these employees are concerned, they had not availed the benefit given by section 11(4). Not only this, a large number of employees, they have not availed this act, and they preferred some writ application. Their writ applications were allowed by the defined high courts. But on appeal, the Supreme Court says no. So far the 11(4) is concerned, there is a specific cut-off date, time you cannot avail this. However, the Supreme Court, in exercise of their power conferred under Article 142, extended the time. That is the judgment that I have annexed. Now, your lordship, come to the statute. Statute. Here in this case below, the person concerned have not availed the benefits conferred under section paragraph 11(4) within a stipulated time. Without availing that, they preferred writ application. There are writ applications were allowed, but the even the Supreme Court has said no. There is a specific time limit, and you have to apply within that period. However, as large number of employees had filed their could not avail this opportunity, a special provisions were benefit was conferred by the judgment by exercising their power under Article 142. Now, page 145, the ratio of that judgment. We accordingly hold and direct that the provision contained in the notification number this much, 11(4), 22nd August 2014, are legal and valid. So, for the present members of the fund are concerned, we have read down the certain provisions of the scheme as applicable to their in their case, and we shall give our finding and direction on these provisions in the subsequent subparagraphs. Number 2, amendment to the provisions the scheme brought about by the notification number such and such dated 22nd August 2014, that is 11(4), shall apply to the employees of the exempted establishment in the same manner as employees of the regular establishment. That is very much important. Here the crux of the problem lies in this case. Transfer of funds from the exempted establishment shall be the manner as we have already did. Transfer of fund means the employer contributed their provident fund to the full salary, but they have disbursed 8.33% to the provident fund authorities for the grant of pension. So remaining fund was lying with the trust pool, and these amounts should be remitted to the provident fund authorities. That is indicated in paragraph 39. The employees who had exercised option under the proviso of 11(3) of 1995 scheme and continued to be serviced as on 1st September 2014 will be guided by the amended provisions of the paragraph 11(4) of the pension scheme. This is not our case because we have not exercised our option under 11(3). Now, 4, the members of the scheme who did not exercise option, that is one thing. Members of the scheme who did not exercise option as contemplated in the proviso to paragraph 11(3) of the pension scheme as it was before 2014 amendment would be entitled to exercise option. Under paragraph 11(4) of the post-amendment scheme. Their right to exercise option before 1st September 2014 stands crystallized in the judgment of this court in R.C. Gupta's case, no, that is, I have just now read it. Applicable to Supra, the scheme as it stood before 1st September 2014 did not provide for any cut-off date, and thus the member shall entitle to exercise option in terms of paragraph 11(4) of the scheme as it stands present. Their exercise of option shall be in the nature of joint options covering the pre-amended paragraph 11(3), also the amended paragraph 11(4) of the present of the pension scheme. There was uncertainty as regards the validity of the post-amendment scheme, which was quashed by the aforesaid judgment of 3 high courts. All these high courts have quashed the judgment. Thus, all the employees who did not exercise option but were entitled to do so, but could not due to the interpretation on cut-off day by authorities, ought to be given a further chance. This was the Supreme Court's power exercise under Article 142. Yeah, ought to be given a further chance to exercise their option. Time to exercise option under paragraph 11(4) of the scheme under these circumstances shall stand extended by a further period of 4 months. We are giving this direction in exercise of our judgment, in exercise of our jurisdiction under Article 142 of the Constitution. So this is the exercise of power under Article 142 of the Constitution. Rest of the requirement as per the amended provision shall comply with. The employees who had retired prior employees who had retired prior to 1st September 2014 without exercising any option under paragraph 11(3) of the pre-amendment scheme have already exited from the membership thereof. They would not be entitled to the benefit of this judgment. The employees who have retired before 1st September 2014 upon exercising option under paragraph 11(3) of the 1999 5 scheme shall be covered by the provisions of the paragraph 11(3) of the pension scheme as to prior to amendment of 2014. Now, last the requirement of the members' contribution at the rate of 1.16 of their salary, the extent of such salary exceeds rupees 15,000 per month, and as an additional contribution under the amendment scheme as held to be ultra vires to the provisions of the scheme of 1952. But for the reason already explained above, we suspend the operation of this part of our order for a period of 6 months. We do so enable the authorities to make adjustment in the scheme so that the additional contribution can be generated from the sum of their legitimate sources within the scope of this act, which could include enhancing the rate of contribution of the employees. We are not speculating on what steps authorities will take, as it could be for the legislature or the framers of the scheme to make necessary amendment or the aforesaid period of 6 months till such time amendment is made, whichever is earlier. The employees' contribution shall be as stopgap measures. The said sum shall be adjustable on the basis of the alteration of the scheme that may be made. We do not find
So
any
essentially, Supreme Court has rejected or interfered with the judgments of the various high courts and upheld the notification. But under 142 gave you extended time to 4 months. But this again, the judgment was kept on hold for 6 months. So from May 23, I think, 4 months would expire on September 20. You have exercised your option.
Yes, we have exercised our.
So whether the respondent authorities can refuse to accept your options.
Initially they accepted by our option.
They accepted, but whether in view of trust rules, there is any restraint in the trust rule, whether your view should override or these restrictions or not, it's not an issue decided by the FSU.
No.
Not an issue decided in the earlier judgment.
On the judge.
So,
Trust rule shall not stand in our way to have the pension on the higher levels. That is our contribution.
because according to the option is conferred on the scheme, on the basis of the scheme,
Yes.
under which the rules are framed. In case of any conflict,
When the trust rules and scheme will prevail. That is the provision that is specifically mentioned at paragraph 27 AA, appendix A, rule 10.
so what you are asking for from this court is a finding that your options will have to prevail over the trust. That's the limited prayer.
But so far our case is concerned, there is no such impediment in our trust rule. Because the fact
No, trust rule, according to the trust rule also does not restrain.
yes.
Then why are you apprehending the implementation of this?
But they have stopped there.
They have stopped.
Grant of pension plus when to us was stopped.
No, but trust rules are not in conflict. In terms of page 210.
This trust rule says that when there is any amendment in the Provident Fund Act or the scheme, we deem that is a part of the trust. That is.
Anything more?
Now, below 163.
163. Instructions.
Compliance with the aforesaid order of the Honorable Supreme Court direction, the central government directed as under. The field officer should implement the direction contained in paragraph 44, 3 and 4 and read with paragraph 44, 5 of the judgment dated 4/11/2022 of the Honorable Supreme Court within a stipulated timeline. As may be seen, the Honorable Supreme Court has pronounced the judgment dated 4/11/2022. The matter of special law petition number such and such. The relevant direction of the court with respect to the above subject are as follows. So they have quoted the Supreme Court judgment. Paragraph 44.3, 44.4. Now they have put it. Paragraph 44.5. Accordingly, the employees who did not exercise option as contemplated in the proviso to the section paragraph 11.3 of the pension scheme as it was done would be entitled to exercise joint option under S12 paragraph 11.3 and existing paragraph 11.4 within the aforesaid extended period of 4 months. The employees who had exercised option under paragraph 11.3 of EPS 1995 and continue to be in service on or after 1st September 2024 will be guided by the amended provisions of the paragraph 11.4 of the pension scheme That is, if they had not exercised option within the time specified in under para 4, such employee shall not be eligible for exercise option.
This does not apply to you. Apply to you.
Now, therefore, the compliance of this Honorable Supreme Court judgment dated 4/11/2022 following employees within their employees with their employers may submit joint action under paragraph 11(3)
No, no,
and
for what purpose are you referring this? It's not applicable to this circular. As far as you are concerned, you have given your options under the extended time.
Yes, this is when a person concerned submit their action option within the time limit prescribed by the Supreme Court, that should be accepted. That is the guidelines here. For the due compliance of the Supreme Court judgment, this circular was issued. How
This is according to you. This is in your favor.
even if it, in terms of this circular, we have exercised our option, and options were accepted, pensions were granted, all on a sudden. Now let's move on. One 70.
Is there anyone for the IOC?
Yes, my friends are there.
You are there.
They are supporting our case. Number 170, that is the demand letter
From the employer to the employer.
Issued by the Employees Provident Fund Organization.
This amount was deposited.
This amount was deposited. And 186. Now we are going to page 186. The new pension was granted, amount pension was granted on higher wages. Pension amount is 37,149. Pensionable salary. Pensionable salary is given below 1,33,583. Our pension granted is 37,149. Similarly, all these petitioners were granted below higher pension. Page 197. Now we will come page 197. That is the reduced pension.
Where is the higher pension for these employees?
Higher pension will find at page 186.
186. Same employee.
With respect to whom? Narayan Swami. One 96. Narayan Goswami, his pension amount was granted 37,149, and pensionable salary your lordship will find 1,33,583. Then Narayan Goswami.
Where is the pensionable salary? Pensionable salary.
Got it. Now we'll also come to page 198. Narayan Goswami. Now pension reduced to 4,156. And pensionable salary is 15,000. Earlier pensionable salary 1,33,000. Now here they have considered the pensionable salary as 15,000. That is the ceiling limit. That was it. Similarly, so far all the petitioners pension was reduced, and their pension was granted to the pensionable salary at the rupees 15. Not considered.
Now the petitioners are receiving the reduced pension.
Your lordship granted an interim order, but they have not complied with that interim order.
Yes.
This aspect of this case was examined. On the Madras High Court judgment, I have annexed the petition, and so far the other judgments are concerned, I have not annexed, but please, with your lordship.
This is Allahabad High Court.
No, your lordship only go page 212 of the read petition. That is the Madras High Court judgment. Madurai bench of Madras High Court. Even paragraph is
Paragraph. Paragraph.
paragraph 42. The circular issued by the respondents on 11/3/2025 that we have annexed here, 18/1/2025 cannot be a violation of the order passed by the Honorable Supreme Court, and this claim is liable to be set aside. Conclusion. In view of the above derivation, this court inclined to pass on the order the impugned writ petition set aside. Any joint option application presented on or before 31/1/25 shall be accepted by the respondent, and on remittance of the differential contribution amount, the pension scheme, the employees' provident fund organization by the employees along with the applicable interest higher pension shall be disbursed to them from the succeeding month of their retirement. Below here, reason Your Lordship may come to page 232. Here. Paragraph 32. Prior to that, they have discussed all the relevant provisions. Paragraph 27A of the Provident Fund Scheme deals with the terms and conditions for granting exemption of an establishment. Condition number 10 of the Appendix A. Any amendment to the schedule scheme which is more beneficial to the employees than the existing rules of the establishment shall be made applicable to them automatically pending formal amendments of the rules of the trust. In view of the aforesaid condition, if the amendment is introduced to the Provident Fund scheme and it is more beneficial to the employees, it becomes automatically applicable to the employees even without a formal amendment, even without evidence of the trust rule. The respondent authorities have pointed out that the unamended trust rules which do not provide for exercising joint option for the remittance of higher contribution to the Provident Fund as per paragraph 27 AA cited supra, even without amendment of trust rules, an amendment made to the Provident Fund scheme automatically applicable to the members of the scheme. In fact, in the present case, admittedly, even without formal amendment, the trust rule, the Employees Provident Fund organization had received higher contribution on the actual wage from the employer and the employee. This fact is not disputed in the counter. In each circumstances, the respondent cannot rely upon the unamended trust rules, which is clearly in violation of the statutory conditions number 10 under Appendix A of paragraph 27AA of the Provident Fund scheme. Now, I have given other three judgments. Two judgments. First, here is yes.
11.
11. And just each eight, 9. Now we have regulated it. Paragraph 11. By the aforesaid determination, the apex code identically situated the matter has held that any joint option presented on or before 31/1/2025 shall be accepted by the respondent as a cutoff date the cutoff date has not been accepted by the apex code in presenting the joint option, and further it is also provided that the remittance of differential contribution to the EPFO by the employees along with the interest higher pension shall be disbursed. Coming to that next issue, which is said to be one of the hurdles for non-payment of higher pension to the petitioners and denial acceptance of the higher contribution, which is apparent that the authorities have taken shelter to the Rule 20.1 of the Trust Rule made under this Act 1952, which provides the limitation of 12% of the contribution, whereas the condition number 10 of Appendix A with the paragraph 27AA of the scheme provides that any amendment to the scheme which is more beneficial to the employees than the existing rules of the establishment shall be made applicable to them automatically, pending formal amendment rules or trust thereof. It is apparent that if any amendment is carved out in the provisions of the Provident Fund scheme, which is more beneficial to the employee, this same shall be automatically applicable to the employees without amending the trust rules. Then in the same line, below. Now the Calcutta High Court judgment. Yes. Calcutta High Court judgment, your lordship will find at our page, serial number page 11. Your lordship can come, go to paragraph 162, page number 72. Page 72. Paragraph 163. As per guidelines from the Employees Provident Fund Organization, headquarter height file pension number such and such dated 18 January 2025. This is the order, my lord. The eligibility of pension.
These are the submissions. These are submissions. The findings start from page 1, paragraph 170.
Paragraph 165. The petitioners, other than the case as may be herein, have stated that the Provident Fund authorities have used affidavit in opposition depicting the joint option form, the exercise of the higher pension on the higher wages were rejected after giving opportunity of hearing to the employer. The persons affected are the employees and they were not harmed. The Honorable Supreme The Honorable Supreme Court in R.C. Gupta School's report in such and such. Clearly, that is the, I have already read it out. Then they have referred the Madurai further argues the petition High Court. 173, they have referred the Madras High Court judgment. Madras High Court judgment. 174, judgment, paragraph 174 in para 35 of the same judgment, which has been held that the trust rule framed under the EPF scheme cannot be cited to deny the benefits under EPF 1995, since the establishment has not been exempted under EPS 1995 in terms of para 39 thereof condition, while granting exemption to one scheme cannot be scoped into another or which no exemption had been granted under this statute. That in this case,
Paragraphs will probably start from 194.
authority has given the own interpretation, which is incomplete, contradiction, violation of the judgment of Sunil Kumar B. Shabrat. There is no such direction, observation of the code of the said judgment. By the said clarification, EPFO has also closed all avenues for getting benefits, directing that the trust rules, if amended after the judgment of Sunil Kumar on 4/11/2022, Such clarification direction is not only complete violation of the direction of the Supreme Court Sujal Kumar B. Supra, but also against the principles of natural justice, considering the EPFO has not only denied the benefit to the members of the exempted establishment, citing task rules, not permitting the scheme, but has gone all out to deny the benefits by issuing clarification dated 18/1/2025, stating that even if the trust rules are amended after the judgment granting benefit, the same would not be available to the members of the exempted establishment. As to how the EPFO agreed, if an employer agrees by filing a joint section form, there being no burden to the authorities if you, in denying the same to the PF authorities are acting against the purpose of the beneficial legislation. Such thought process and the conduct of the authorities who are to implement this beneficial legislation is not acceptable by this court. At the same time, is not only against the principles of natural justice, but is clearly in abuse of the process of law, being not in accordance with the law. Accordingly, the order dated 11/1/2025 and the order dated 5/2/2025 are hereby quashed and set aside. Any joint option application presented on or before 31/1/25 or being any other further extension of time by the authority considered, if any, shall be accepted by the respondent. On remittance of the differential contribution amount to the petition pension scheme to the employees provident fund organization by the employee along with the applicable
Yes.
provident fund organization by the employees along with the applicable interest higher pension shall be disbursed to them from succeeding month of their remittance. So basically, because the pension is a property earned through the past pensionable service. That property cannot be taken away without any procedure established by law. Here they are taking away by property by citing the trust rule, which is not a provisions of law. Yes. Well, that is, if we go through the mandate of Article 300A, it is clear that no person should be deprived of their property save as other authority of law. Now they are depriving my property of pension by citing the test rule, which is not authority of law, but the authority of law is clearly stated under paragraph 27AA, read with the 10 of Appendix A. That is my submission.
I'm told my lord will rise early today. My lord,
We have 15 minutes to conclude.
Lord, at least I can make a preliminary submission on the judgments of the High Court.
Did you find it funny because we gave you more time or less time?
I would not venture against, my lord. I would not venture against.
Yes.
But one preliminary submission. The judgments of the High Courts, Madras, Madhai Bench, Calcutta, and Allahabad were all against us. All three have been stayed by the respective divisions.
Of the respective high court.
Yes. Why at all we are restricting these petitioners' pension? Why the division benches were compelled to stay all these orders? But there is a fundamental problem in all. Under the pension scheme, I am only submitting on first principles. I request my lord to go through the rules later when we argue them. But on first principles, pension scheme requires an employee to contribute every month to the pension fund. The reason is that at the end of the year, PFO set the entire corpus it has and it plans. Because the pension which commences at the time of retirement should be sustainable. Because then thereafter no contributions are coming then. So whatever a person has contributed throughout his service period, we periodically plan it to ensure that upon retirement, this person should get pension. On his demise, his dependent should also get pension. So that planning, that sustainable planning we do every year. That's a statutory mandate under the pension. What's happening here is, as rightly submitted by the minister, none of the petitioners contributed to the pension scheme higher rates during this. Not one of them. They all decided to contribute to their provident funds. The choice was very obvious for them. Almost everybody in the country, my lord, there were almost 1 crore subscribers at that point in time. Almost everybody had decided to contribute the bulk of their contributions to PF, not to pension. Obviously, because at the time of their retirement, they would get this huge corpus as PF, whereas in pension, they would get it every month over an extended period of time. So they all wanted the money upfront at the time of retirement. So everybody chose consciously to contribute to PF, not to pension. Today, when they turn around and say that please take my money now and then refix my pension, effectively they're asking us to pay them pension on sums which they had never contributed to begin with. For this entire 35 odd years of their membership of the pension scheme, they never contributed. Today their argument is, take the money now. For the last 30 years, we never got to plan this fund.
But you granted them higher pension.
Well, that was an error which we cured. So when we requested them that we have fixed your pension pursuant to Sunil Kumar's judgment, when we fixed the pension incorrectly, we reached out to the petitioners, asking them that, see, there was an error on our part. We took contributions incorrectly from you. Please furnish us your bank account. We'll remit the money. Not one of them furnished their bank accounts. So we were precluded from refunding the money immediately. Instead of that, they preferred this writ petition. Had they had furnished their bank accounts, we would have refunded the money within a day.
That's not even their prayer.
So they are saying that they are effectively presenting us with a fait accompli. We made an error in taking money from them. Now they are saying let that error be perpetuated. Since you have taken the money, you please treat us under the Article 142 directions of the Supreme Court and fix pension for us. Long and short of this is, Manu, that series of directions under paragraph 44.3 says that those who had opted, my lord, will please have 44.3 for it. Page 145, my lord, may I, my lord? My lord, on 146, 3 and 4 are reproduced. This entire dispute is, my lord, according to us, they fall under 3. According to them, they fall under 4. This is the sum and substance of this. Under 3, it says employees who had exercised the option under the proviso to para 11.3 of the 1995 scheme and continued to be in service as on 1st September 14 will be guided by the amended provisions of 11.3. What it means really is this, my lord. Under the proviso to 11.3, they had to choose between PF and pension. Our submission, our understanding is they made that explicit conscious choice by framing trust rules, which said that their money will be confined to PF, would not be sent to pension. So they made that self-imposed restriction to their own benefit because they all wanted the money to be confined to PF. That places them under 3. 4, my lord, in sharp contrast, refers to a situation of indecision. May I place 4? Members of the scheme who did not exercise the option. The opening sentence says they shouldn't have exercised the option. As contemplated in the proviso to para 11.3 of the pensions.
You say option is
yes, my lord. The rules were framed by they themselves. So then I'll invite my lord's attention to the statutory provisions under which the rules are framed. The statute requires their consent for the rules to come into effect. Those are statutory rules. They consciously frame the rules that all that they contribute must remain in PF, must not go into pension. So once they have consciously chosen a certain state of affairs, retrospectively they are asking us to disregard that choice and place them under 142 directions. That's stretching 142 a bit too much, in my respect. So my lord may see, Roman 4 says, members of the scheme who did not exercise the option as contemplated in the proviso to para 11.3 of the pension scheme as it was before 2014 amendment.
Under the rules, what was the option they exercised?
PF.
No contribution at all.
So my lord, how it operates is, under the pension scheme, everybody must contribute to both PF and pension up to that wage threshold, which is now 15,000, earlier 6,500 and 5,000. So up to that limit, up to that extent of wages, everybody contributes to both the funds, PF and pension. But contributions beyond that are mutually exclusive. One must choose for salary exceeding 15,000, whether the money should be diverted to pension or should be retained in PF. Because, my lord, eventually, what happens?
That
the
is
idea
that is on an option to be given individually.
Yes, my lord, individually. Because it is for the person to plan his social security, his retirement benefit. The individual decides whether he wants PF in life or pension. The statute says up to a certain threshold, you are compelled to take both. The idea is, my lord, if somebody retires and his PF is abused, stolen, his children can misuse it. At least his pension, that bare minimum pension, will sustain him. So the idea was, under all circumstances, please ensure everybody has a minimum threshold of both. But beyond that minimum threshold, the individual should exercise a choice between PF and pension. That was the proviso to 11.3. Now, they consciously chose for PF. Admittedly, they never contributed to pension beyond the threshold. That choice, recorded in their trust rules, is covered under this Roman 3 of this judgment. And 4, my lord may see, 4 clarifies where it applies. My lord may please see, I'll just quickly read through this direction, my lord. The members of the scheme who did not exercise the option as contemplated in the proviso to para 11.3 of the pension scheme as it was before 14 amendment would be entitled to exercise the option under 11.4 of the post amendment. Their right to exercise the option before 1st September 14 stood crystallized in the judgment of this court in RC. We have no dispute with any of this. The scheme as it stood before 1st September 14 did not provide for any cutoff date, and thus those members shall be entitled to exercise the option in terms of 11.4 of the scheme as it stands at present. Their exercise of option shall be in the nature of a joint option covering pre-amendment paragraph 11.3 as also amended paragraph 11.4 pension scheme. Now please see the uncertainty when this direction gets invoked. There was uncertainty as regards validity of the post-amendment scheme, which was quashed by all the aforesaid judgments of the 3 High Courts. Thus, all the employees who did not exercise the option but were entitled to do so, but could not due to the interpretation on cutoff date by the authorities, ought to have been given a further chance to exercise their option. Time to exercise the option.
So what you're saying is, this extended period of time
Yes,
will not be applicable for people who already exercise their option.
Exactly. Otherwise,
So you were
11.3
saying
becomes
that the exercise of options are as defined under the rules.
Yes,
we trust.
Yes.
That clarification, that reading is not available.
May I explain what I'm trying to submit? Please see Roman 3. Roman 3 says the choices under 11.3.
You'll have to write.
Yes.
You continue.
May we consult between and request a date according to the court master, then my lord may.
We are closed for
I realize, my lord, I realize.
vacation.
For BU vacations. My lord, which 2nd of May be convenient, my lord? We were looking at it. It's a Saturday. Subject to my lord's convenience.
Let's have it on 30th of April, in case we are unable to proceed.
Hello.
I mean, if we are unable to close the matter, then we have the 2nd of May option.
It looks a little difficult. I'm so sorry I'm making this request.
You want 2nd of May?
2nd is a Saturday, my lord. That's why, because we may have an extended then. 2nd is a working Saturday. Subject to my lord's convenience. Otherwise, we'll make do.
On 2nd, but see, there's a commission which I'm heading. So
All right.
there are some hearings to be undertaken. Therefore, normally,
I
try to do it. Then if we sit on 2nd,
I'll request only for half an hour to 45 minutes, not more.
but we'd like to take the judgment of the 100%.
The other,
So therefore, I was thinking 30th is available for you, which is the Thursday.
the other thing is on 6th, that appeal before the Calcutta High Court might get decided.
On 6th
Yes,
of
the coming 6th, my lord, next
May.
week.
No, this 6th.
Yes, April. So we may have a situation where there is a judgment which further clarifies things, which may be of some assistance to either of us.
Then let's have it on 7th or some 7th or 14th.
Of April or May? May. About 14th?
Yes, 14th May.
Yes.
Go further hearing on 14th May.
I'm grateful.
Counsel to the petitioner is arguments reserving his right for a right. Counsel for respondent for further hearing on 14th of May.
Grateful.
Rest of the matters, you take your dates.
Interim order is there.
Interim order in item
34 and 35.
34, 35. Interim order, if any, on 34 and 35, stand extended, matter be listed again. 6th of